SJC-11846 in the matter of Chandrakant Sridhar Panse.
Mr. Panse, good morning. When you get settled, you can take the podium.
Thank you.
You will see a clock in front of you, and you have 10 minutes for your argument.
Good morning, and may it please the court. I am Chandrakant Panse, petitioner. I would like to thank the court for the opportunity to be heard, and I'm particularly grateful to Justice Dr. Lenk for reporting the matter. If the court will kindly pardon me for the cold that I'm suffering from. Mr. Chief Justice, I understand that there is no rebuttal allowed here, but this is an extraordinarily unusual case, excuse me, in that really extraordinary attempts by the appellee board to mislead this court, and so I would suggest that the interest of justice warrant some rebuttal time.
I think you're going to be limited to the time you have, so why don't you focus on using the 9 minutes you have as best as you can.
Thank you, Mr. Chief Justice. If I may spend a minute commenting on a couple of facts. Facts number 13 and 25 on pages 7, 8, and 11, 12, respectively, of my blue brief. Those are admissions that my child's mother, and my child being severely, severely disabled, the child's mother was not capable of taking care of the child and got the custody. If I may bring to the court's attention facts number 21, 23, and 24 on pages 10, 11, they describe the deplorable state that my child was left in. Those facts have been established years ago in courts under the rules of evidence and under the rules of domestic relations procedure. And for now, for the appellee board to come here and challenge the facts and to claim that there are no facts is extremely troubling. What I would submit to this court is the condition of my child, that the child was left in for years, does constitute felony endangerment. And as I have submitted to the court, every member of the society, every citizen who comes across these facts, who becomes privy to the documentation, has a common law duty to so report. And finally, the fact number 15, which I submit, stands adoptively admitted to this court, describing the appellee board's witnesses denying that a child with disabilities is entitled to any hygienic care. And not only that, but further, the appellee board itself participating in that viciousness. And that is completely against the standards of this society. If I may move on to the argument, I would like to make a couple of introductory observations. Number one, as far as I can tell, the Supreme Court of the United States has reversed every single attempt by a state Supreme Court to deny a bar admission case. the holdings of the United States Supreme Court make it a almost insurmountable burden for the state to deny admission to the bar, short of something unusual, such as a criminal record for frauds, and that record being recent. And secondly, I would submit that the appellee board should be denied the ability to apply a double standard. I cannot be compared with the Pope here. I must be compared with the other members of the bar. Here, there are members of the bar who went after the custody of my child when the child's mother could not care for him, left the child in deplorable condition, and I don't quite see how that is not felony endangerment. And those are the heroes, those attorneys are the heroes for the appellee board, and I'm the bad party. The appellee board describes the justices of the Supreme Court of the United States as mere politicians who could be attacked as fascists. And this board then turns around and says that I do not have respect for the law. That should be completely impermissible, and this court should not stand for it. If I may talk about a couple of major issues, argument-wise. First of all, jurisdiction, and then I'll talk a little bit about speech. As for the jurisdiction, the Supreme Court of the United States is absolutely clear that the due process must be very timely, and a bar admission case must receive more stringent scrutiny about the timeliness. Now, I had a colleague who wrote a letter of support for my admission. 5 years after he wrote that letter, we had a political fallout, we had a disagreement at work. He elected to withdraw that letter. 5 years after the letter was written. Beautiful marriages can fall apart in a lot shorter time. So that is the prejudice caused by the refusal to deny timely due process. We would not be having this argument at all if the due process was timely. The second part of my jurisdiction argument is the soft jurisdiction. People who are not horrified by the condition in which my child was left should not be commenting on anybody else's morality. Moving on to the speech issues, there is a lot said about what I said, where I said, and how I said it. The Supreme Court of the United States is crystal clear in Konigsberg. We need an independent and unintimidated bar. As for the speech particulars, I would like to say two things. One, the Supreme Court of the United States requires context. And the case that the appellee board had cited on page 36 of their brief in matter of application has one critical word, unreasonable. When your child is being subjected to felony abuse by court orders, nothing you say in a court of law, short of using unparliamentary language, is unreasonable speech. The context is critical. The speech must be placed in the context. The United States Supreme Court requires it. The context here must be examined before my speech can be examined. The same goes for other cases in which my speech has been attacked. I have been a tenured professor. The Commonwealth of Massachusetts terminated me. An arbitrator made a finding of fact that there was absolutely nothing there. The Commonwealth could not even impose simple discipline. The Commonwealth dragged out an arbitration for more than 4 years. If that is not outrageous, I don't know what is. for denying me a salary for 4 years, although they had to pay back pay. That came much later, denying my little kids health insurance for 4 years. It is that context in which all speech must be noted. One cannot just say he wrote this, he wrote that. Another very critical point in that is, I never wrote anything, howsoever unpleasant, that cannot be supported by facts. What I wrote was absolute truth. Now, if the truth hurts, nothing I can do about it. But to claim that I am somehow immoral for writing truthfully defies justice.
Are you currently a professor at Mass Bay Community College?
Yes, Justice Bosper.
All right. Well, thank you, sir.
Thank you very much.
Good afternoon, Your Honors. May it please the Court. Elizabeth Kelly on behalf of the Board of Bar Examiners. Dr. Panse has not met his burden to establish his character and fitness necessary to be admitted to the bar. The Board was justified in finding significant doubts about Dr. Panse's character based on his lack of candor, his inability to conduct himself with respect for the law, and his lack of civility and professionalism in his pro se litigation. I will discuss these three issues in turn and also address Dr. Panse's due process and First Amendment arguments. As for the standard of review, this Court gives deference to the Board, but has the final decision on Dr. Panse's qualifications. Turning to the issue of candor, the Board found that Dr. Panse's failure to disclose several adverse legal decisions on his bar application demonstrated a lack of candor. Most troubling, Dr. Panse failed to disclose the fact that the First Circuit Court of Appeals had upheld the dismissal of his lawsuit, his pro se 1983 lawsuit, against his ex-wife lawyer, and his ex-wife lawyer's law firm, and ordered him to pay sanctions. This occurred while he was a law student applying to the bar. Dr. Panse also misrepresented the outcome of a defamation action he brought against Tufts and another defendant in 2001 that lasted until 2003. In which costs were awarded to the defendants by the trial court and on appeal, but in his application, he claimed that costs were denied. Dr. Panse also misrepresented the disposition of a lawsuit filed against him by his landlord. He claimed that there was granted a 3-month extension of the lease. However, a summary process judgment entered in favor of the landlord, and Dr. Panse also failed to disclose this and the fact that his counterclaim was dismissed and the landlord was awarded attorney's fees, and that he filed an appeal that was later settled by the parties. Dr. Panse also failed to disclose on his application that he filed action against a car dealer that was dismissed by the Superior Court for failure to meet the jurisdictional requirements. Taken together, all of these misrepresentations and omissions on his bar application are material, and they do show a lack of candor. These actions were in the public record, and Dr. Panse's failure to represent them accurately and completely remains troubling and inadequately explained. The Board correctly found that Dr. Panse has consistently shown an inability to conduct himself with respect for the law. Among the many examples cited by the Board, Dr. Panse has shown his disregard for the law by filing numerous and unsuccessful pro se lawsuits and appeals in state and federal courts, many resulting in sanctions and fees awarded. He's also failed to promptly pay sanctions ordered by the First Circuit and only paid them after the bar initiated its investigation against him. He's also refused to execute documents pursuant to a court order, which would result in a contempt order and an award of attorney's fees. He's used the legal process to insult, degrade, and intimidate his perceived adversaries in court filings and at hearings. He raises irrelevant issues in incorrect forums, and he's filed professional complaints against 14 attorneys who challenge his positions. He's refused to accept the finality of the court orders and failed appeals. Most of this occurred while he was a mature adult law student. This court has previously denied admission on similar facts. In Britain versus Board of Bar Examiners, Like Dr. Panse, the petitioner had a substantial history of initiating pro se litigation, the majority of which had been unsuccessful, and some of which had resulted in sanctions or orders to pay restitution. The court denied admission based on these facts, coupled with the petitioner's lack of candor and failure to make disclosures in his bar application, as is the case here. The board found that Dr. Panse has consistently relied on personal attacks to justify his actions and has lobbed attacks at anyone who has challenged his perceived version of the facts. The board looked at his penchant for making unsubstantiated and outrageous accusations and engaging in name-calling and court filings, which are documented throughout the record. Dr. Panse says here that everything he has said has been fact. While I would question whether calling someone a reject from Montana in a court filing is a fact, or whether calling his ex-wife a court order violating freeloader is actual fact. The three attorneys who objected to his admission and testified at his hearing gave examples, specific examples, showing how Dr. Panse has used the legal process to inflict harm on others. Dr. Panse's dedication to seeking revenge is highlighted by the fact that days before his character and fitness hearing, he filed unfounded professional complaints against the lawyers who had objected to his admission. He calls just about everyone involved in the admission decision, including the board and the attorneys engaged by the board, liars, aiders, and abettors of child abuse, and accuses them of committing crimes against moral turpitude. His justifications for making such wild accusations are based on mischaracterizations of the record and are completely unsubstantiated. Dr. Panse sums it up for himself when he says, "Civility cannot be employed to avoid justice." Dr. Panse's complaints about the board's process are unfounded. The records show he was given an informal interview, notice, and a hearing, a chance to confront his witnesses who testified against his admission, and to call his own witnesses, which he did not do. He argues that the delay of the board's decision amounted to a due process violation and justifies his admission to the bar. But as set forth in the board's brief, each step of the investigation was performed in a prompt manner. And the delayed hearing was caused by Dr. Panse's own actions in filing BBO complaints against his accusers. He complains that the board took too long in commencing the investigation, but the record shows that the board was engaged in looking for a suitable pro bono counsel. And the fact that the board delayed its ultimate decision after the hearing was for Dr. Panse's benefit. It should have given him the time and reflection needed to satisfy his burden of showing his character and fitness, but it did not.
With regard to the complaints he filed against the attorneys who complained against him, is the disposition of that a matter of public record?
The complaints, it's in the record before the court, Your Honor, yes. The BBO rejected his complaints and said that they were unfounded and lacked any documentation whatsoever. In any event, even considering delay as it amounts to a due process concern, it does not justify admission to the bar. As stated in Justice Goldberg's concurring opinion in the Wilner case, where a board's findings are evidenced by documents and the petitioner's own statements, as they are here, and the petitioner has had an opportunity to explain his case, which he has, the board's ultimate recommendation cannot be challenged on due process grounds. Dr. Panse's jurisdictional arguments are likewise without merit. And turning to his First Amendment argument, I'd like to first state that Dr. Panse has again mischaracterized the facts of the case of Koningsberg. In that case, Koningsberg did criticize the Supreme Court justices, but he also criticized the leaders of major political parties. So the board has not indeed called the Supreme Court justices political leaders. He complains that his First Amendment rights were infringed by denying him admission based on his past statements. While the board has considered Dr. Panse's past statements, it was in connection with his conduct in filing vexatious litigation. The two cases of Law Students Research Council versus Wadmond, 401 U.S. 154, and Koningsberg, the second Koningsberg case that came after the one that Dr. Panse refers to, versus State Bar of California, 81 U.S. 997, make it clear that the Bar Commission is allowed to consider speech and conduct in making its determinations on an applicant's character. As for Dr. Panse's repeated accusations about the purported abuse of his child by his ex-wife and the purported aiding and abetting of such abuse by her attorneys, the Board of Bar Examiners and its attorneys, and just about everybody else, the Probate and Family Court conclusively determined on March 1st, 2010, that, quote, there is no evidence that the mother's current care was detrimental to the health, safety, or welfare of either child. Dr. Panse claims that he has expressed regret for his past litigiousness, yet he continues to repeat these basic accusations and tries to have them referred for prosecution by this court. This is not the hallmark of regret. For these reasons, the court should dismiss Dr. Panse's application and deny him admission to the bar. Thank you.
All right, thank you.
All right.